Hello. In this short video, I will be discussing 5 fundamental things that you need to know if you're planning on letting your land to a mobile phone mast operator, and even if you aren't. Mobile phone operators are protected by legislation known as the Electronic Communications Code. The code has been in force in one form or another for many years, but was updated in 2017 to enable the 5G rollout. The code was redesigned from the ground up to make it attractive to mobile phone operators. I'm going to run you through the main aspects of it. If a telecoms operator has identified your land as a possible place to put a mast, it will initially want to carry out what is known as a multi-skilled visit, or MSV. The MSV is a site survey at which engineers will attend your land in order to assess the suitability of the site for the location of a mast. The MSV will take probably only a few hours, so is not in itself objectionable, but it is the start of a process which could ultimately lead to an agreement being imposed on you. And so some landowners may wish to refuse access. But ultimately that is unlikely to be possible, because the operator can apply to the tribunal for an order requiring you to give access. And the tribunal will grant that order unless you can show convincing reasons why the prejudice to you outweighs the public benefit in having a mast in that location, or if you're planning a redevelopment of the site. And neither of those things is going to be easy to prove. Once the MSV has taken place, assuming the operator deems the site to be suitable, it will suggest terms for an agreement allowing it to install the equipment on your land and keep it there for a period of time, say 10 years. If terms cannot be agreed, the operator can apply to the tribunal for an order requiring you to grant it an agreement. And just like the MSV, you can only oppose that agreement on very limited grounds. You must be either planning a redevelopment, or you must be able to prove that the prejudice to you outweighs the public benefit. But the starting point for the tribunal is that the public benefit derived from having a choice of high quality mobile phone networks is very high indeed. So you're starting the match 3-0 down. It is hard to think of many situations where the prejudice to a single landowner would trump the public benefit. The cards are very much stacked in the operator's favour. So what about the terms of the agreement? Well, in setting the terms, the tribunal will try to strike a fair balance between the parties, but there are some provisions that the code guarantees. For example, operators can assign the agreement to other code operators without requiring the landowner's consent. And subject to some limited exceptions, they can also share their mast with other operators and upgrade their equipment, again without your consent and without any ability for you to charge a payment for the privilege. Long gone are the days when you could charge tens of thousands of pounds for a mobile phone mast sited on your rooftop or in the corner of a field. The new code requires valuation of the rent to be on the basis of various fictitious assumptions, one of which is that the agreement doesn't relate to the provision of a communications network at all. And if your land is the only land where the mast could be situated, that fact is ignored. The effect of these assumptions is that the rents being ordered by the tribunal are considerably lower than they were prior to 2017. In the case of Cornerstone and London Quadrant, for example, the tribunal ordered an annual rent of £5,000 for a mast on a rooftop of a London block of flats. So once the agreement has been entered into, whether voluntarily or ordered by a court, it enjoys very strong statutory protection. Assuming the agreement is granted for a fixed period of time, say 5 or 10 years, the right to keep the equipment there doesn't end at the end of that period. It carries on the same terms until one or other party serves a notice, either requesting a new agreement or asking for the agreement to be terminated. A landowner wishing to terminate the agreement must give 18 months' notice, setting out one or more of the statutory grounds for possession of the land. There are several grounds, and I'm not going to go into them all here, but the main one is perhaps where a redevelopment of the land is proposed. Assuming the operator serves the relevant counter notice in response, the agreement can then only be terminated if ordered by a tribunal, and the tribunal has to be satisfied that the landowner's ground or grounds are made out. But once the agreement is terminated, that's not the end of the story, because the landowner must serve another notice requiring the removal of the equipment. And if the terms of removal cannot be agreed within 28 days, a further application to the tribunal must be made for a removal order. So, all in all, letting your land to a mobile phone mast operator is not the attractive proposition that it perhaps once was. And things have in theory got better for the mobile phone operators, but landowners are now so wary of entering into agreements with them that operators are fighting expensive and time-consuming battles all across the country. So perhaps there are no clear winners. And that is in part why the government has recently consulted interested parties about possible changes to the code. So watch this space for further updates when the outcome of that consultation is known.